And a News 4 Consumer investigation gets immediate action by a major car manufacturer. Our investigation discovered a carbon monoxide leak in this Maryland couple's car, and within days, Ford sent engineers to test and repair it.
For right now, we don't know exactly what they're doing, and we're still not convinced that this vehicle is completely repaired properly.
So what has this couple so upset now?
That's the question. Our consumer investigative reporter Susan Hogan joins us now with details you will only see here on News 4. Susan?
Well, that's right. When we had the Shedrick's car tested for carbon monoxide a few weeks ago, as you may remember, a toxicologist found elevated levels. So we alerted Ford. Within days, the manufacturer sent engineers to Maryland to inspect their SUV. However, this couple says they're still not satisfied and they want answers.
Right.
Mark and Valentina Shedrick are refusing to drive their Ford Explorer.
I'm still not convinced that this vehicle is safe for me to drive.
Days after our News 4 consumer investigation revealed carbon monoxide inside their 2016 Explorer, Ford sent engineers to inspect their SUV. They took it out for what Ford tells us was an in-vehicle drive evaluation. They tested for carbon monoxide. The Shedricks tell us the engineers detected it, although they refused to put the results in writing.
And I'm like, what is it going to take for me to get a black and white copy with the, elevated levels of the carbon monoxide?
When News 4 asked Ford why the engineers wouldn't document the carbon monoxide levels, we were told the Ford engineers who investigated the customer's vehicle did not generate a written report. They provided the information from our investigation directly to the customer verbally. This response has one car safety expert questioning Ford's motives.
And why wouldn't they put it in writing?
Well, no data, no problem.
Ford serviced the Shedrick's vehicle and took it out for another test drive and found consistent carbon monoxide readings near zero. That they documented. And when we had their vehicle retested, we found the same. The Shedrick's case isn't unique. In fact, the National Highway Traffic and Safety Administration is investigating 2,700 complaints from Ford Explorer owners who say fumes or carbon monoxide is leaking into their SUVs and making them sick.
It's been going on for a number of years.
Ford continues to say it has not found carbon monoxide levels in non-police Explorers that present a risk to safety. But what exactly is that level?
There is no federal standard for motor vehicles for interior cabin air quality, particularly carbon monoxide.
In a letter sent to federal regulators, Ford says when it tested several Explorers, it found levels of carbon monoxide well below its own internal air quality standards. But when News 4 asked what those standards are, Ford told us there is no standard specifically for vehicle interiors. They went on to say Ford references a variety of government standards, guidelines, and sources to ensure the safety of our vehicles. One of those references, the Global Vehicle Interior Air Quality Standard. But we couldn't find any such standard, and several air quality experts we spoke with have never even heard of it. When we asked Ford where this standard came from, they declined to give us any information.
Tonight, we're working for you to make your next move as stress-free as possible.
At 5, we introduced you to a guy who went through what he called the move from hell. Not only did his movers leave him with a long list of broken and misplaced stuff, the company may have violated 3 consumer protection laws in Maryland.
Tonight, our consumer investigators are uncovering a troubling trend with this company, and they've got some surprising details about who's watching over movers in the state. Susan Hogan here now with a story you'll see only on News 4.
Well, that's right. This story first came to us as an NBC4 Response complaint. But once we started digging, we realized the problem goes well beyond this one move and this one company.
And this is one of those boxes.
Al Wilkins is busy getting settled into his new home. He's trying to forget the nightmare move that dragged on for 4 days. Swift Van Lines may not have complied with 3 Maryland consumer protection laws during that move. They charged 400% of the estimate given to Al. They held his goods hostage until they got paid in cash and never gave Al a receipt.
In every instance of a violation of the Consumer Protection Act, there is a potential fine of $1,000.
That's Maryland Attorney General Brian Frosch. Al filed a complaint with his office after the move. The Attorney General can't comment on his case since it's still open, but he has taken legal action against moving companies in the past.
If we find that kind of activity anywhere else, we are going to pursue it, and we're going to get justice for the consumers who were ripped off.
The way that they did me, I wouldn't want that to happen to anybody, and I know that it's happening. So, my thing was, this has to be stopped.
This is what Al's referring to. Several complaints on the website ripoffreport.com detailing nearly identical scenarios. The movers from Swift Van Lines showing up late, holding goods hostage, and demanding cash payment. We called the company's owner, Juan Carlos Martinez. He hung up on us 3 times. We also texted him, but he never responded. We went to the address listed on the estimate he gave Al. Turns out it belongs to another moving company. We also went to Martinez's home address. He wasn't there, but a family member was. She wouldn't open the door and told us she didn't know where he was. We started digging deeper into the history of Swift Van Lines. We found this document, which shows Martinez created the company in Maryland in 2013. Back then, it was named Revolution Moving and Storage, LLC. In April 2016, the Maryland Insurance Administration fined Revolution $7,500 for providing a fraudulent certificate of insurance to a potential client in 2015. 1 month earlier, Martinez filed this document with the state, changing the name of his company to Swift Van Lines, LLC. The state tells us to this day, Martinez has never paid that fine. He also has not filed a personal property return for his business since 2015. This is Swift Van Lines' website. They claim to be accredited by the Better Business Bureau, but that's not true. We alerted the BBB, and they say they sent the company a cease and desist letter. Angie's List says it is also taking action for misuse of its logo. And take a look at this. Swift Van Lines advertises for long-distance moves, but we've confirmed with the Federal Motor Carrier Safety Administration that the company does not have the authority to conduct interstate moves. In Al's case, he moved within Maryland, so federal authority is not required. The state allows moving companies to operate as long as they have a valid U.S. or Maryland DOT number, which Martinez does.
You don't need a license to operate in Maryland. So
Attorney General Frosch tells us if licenses were required in the state, Martinez would likely no longer have one because of that unpaid $7,500 fine.
There's a clear line that would stop folks like these from continuing to rip consumers off.
So should there be one agency watching over these companies?
That's a question for the Maryland General Assembly, and it's a good one.
We shared the findings of our investigation with State Delegate Robert Flanagan. He was surprised to learn about the lack of regulation and oversight and is now drafting a bill to change that.
Craft legislation that doesn't harm the good ones, that encourages people to make wise choices when they select movers, but really puts the boot and kicks out those people who are taking advantage of the system and really ripping off consumers.
He'd also like to see stricter penalties for those who violate certain parts of the Consumer Protection Act.
I think we need to make it very clear in the law that if there is a violation, a clear violation, and refusal to turn over goods, that if that is flagrant, it should really be a criminal violation.
Delegate Flanagan points out that there are a lot of good moving companies, but he has a message for the ones who try to take advantage of consumers.
Well, watch out. We are going to go after you, and from the legislative point of view, we're going to be working on it next year. You're not going to stay in business very long.
And Delegate Flanagan tells us the Attorney General's office or the Department of Labor Licensing and Regulation would likely be the ones responsible for overseeing moving companies. Attorney General Frosch says he would support this legislation. Now,
we've got a warning tonight about an illegal practice. It's called slamming. It's when utility customers are signed up with a third-party supplier without their permission. Consumer reporter Susan Hogan details what you need to know to keep it from happening to you.
well, many of you use these third-party suppliers for your gas or electric, and many of these companies do promise big savings. While most of you willingly signed up, we've learned some of you may have been switched without your knowledge. Slamming could happen by phone or from a knock at your door.
And I said, well, who are they? And,
or in Karen Franklin's case, a mysterious charge just showed up on her gas bill.
And, when did I change? Because I had no recollection of ever signing a contract with them.
Karen believes she is a victim of slamming.
Slamming is a particular situation where you get signed up for a product or service that you did not contract for.
So how do you know you've been slammed? Take a look at your utility bill and look who supplies your gas or electric. If it's a company you've never heard of before, you may have been illegally switched. To prevent slamming, be careful what you share with door-to-door salespeople. If they ask to see your utility bill, refuse, and never let them see your account number.
They copy that down, they put it on a contract, somebody signs their name to the contract.
Beware of telemarketers who lead you to believe you're talking to your utility company. Before agreeing to anything, confirm who you are actually talking to. Notify your energy supplier immediately if you receive a call or notice to verify a change in your energy service that you didn't authorize. In Karen's case, the third-party supplier couldn't find any record of a signed contract and agreed to cancel her account. Now, by law, a third-party supplier in Maryland must get a customer to sign a contract. However, in D.C. and Virginia, a verbal okay seals the deal. Now, our story continues online for you right now, so check out what third parties are licensed to do business in your state and what you need to ask before agreeing to switch. I'm Susan Hogan, News 4.